Hi, I'm Annie Fitzsimmons. I'm your Washington Realtors Legal Hotline Lawyer. And this is another episode in our series entitled, You Are Practicing Law. Is It Authorized? In this series, we are fully digesting the limitations of your authority to draft a purchase and sale agreement, to select the forms to use, and to draft the language in the purchase and sale agreement as defined by the Washington State Supreme Court in the 1985 Cultum versus Heritage House case. And as a refresher, the scope of your authority is this from the court's decision. Our decision provides that a real estate broker is permitted to complete simple, printed, standardized real estate forms, which forms must be approved by a lawyer, it being understood that these forms shall not be used for other than simple real estate transactions which arise in the usual course of the broker's business, and goes on from there. I'm short-circuiting that language because I want to focus on the word simple. Because most of you would find it laughable to think that you are only allowed to draft contracts in simple transactions, because as you think back over the length of your career, whether it's a year or 30 years, I suspect most of you would not be able to identify a single transaction that was simple. And yet the court says you are only allowed to use simple forms in simple transactions. So what on earth did the court mean if it didn't mean the obvious, which is that you wouldn't have any authority at all because there is no such thing as a simple real estate transaction, and goodness knows there is no such thing as simple forms when we have over 100 forms in the statewide form system. So the court gave us additional definition of what that term simple means in the court's decision. And again, I want to read the court's own words to you. In a few instances, purchase agreements may be complicated, and one or both parties may realize the need for a lawyer to prepare the contract rather than use a standardized form. In fact, if a broker or salesperson believes there may be complicated legal issues involved, he or she should persuade the parties to seek legal advice. More often, however, these transactions are simple enough so that standardized forms will suffice. So what the court said with this language is that the court trusts you to know when a transaction, although none of them are truly simple, when a transaction is more complicated than the scope of your authority or the scope of your abilities allows you to handle. When you are asked to draft a quick easement for the parties so that they can close the transaction, that is not something that is within the scope of your authority to draft. That is not part of a purchase and sale agreement. You are not licensed nor authorized to draft an easement agreement. When you're asked to draft a holdback agreement, I would assert that is not a simple transaction. That is a transaction that creates an obligation between the parties after the closing of the purchase and sale agreement. A holdback agreement is not a simple transaction or a simple agreement. If you are asked to draft a contract where property itself, interests in the property are being divided among multiple buyers, that's not a simple transaction. In fact, that's probably a securities transaction. You're not licensed to draft that. When you're asked to draft a contract dealing with complicated issues of personal property or complicated issues of corrective action on the property, sometimes sellers, for example, want to be able to be obligated to make corrections after closing, after they've gotten the funding from the transaction, then they'll make the correction to the property. How does buyer get protected for that? Well, that's not a simple scenario either. These are examples from my experience as a hotline lawyer of scenarios where brokers have presented with me with a set of facts and said, how would I draft this language? And my answer in all of those is you shouldn't draft that language. There are as many transactions as there are out there. There are other examples of what is not a simple transaction. I cannot begin to give you in this episode an example of every not simple transaction you might encounter. Instead, the court said, real estate industry, we as the court trust you to determine when something is not simple. There's the famous old adage where the court was once asked to define pornography, and the court said, can't really define pornography, but we know it when we see it. It's the same scenario here. The court is saying, we expect you as a member, a licensed member of this industry, trusted by the state through the licensing authority to represent parties in the singularly largest financial transaction of most of their lives. When we entrust you with that authority, we are further entrusting you to recognize when a required form or a transaction itself is not simple enough for you as a non-lawyer to draft. And in that scenario, the court said you are required to persuade your client to seek legal counsel. What does that mean? How do you persuade somebody? Because there's some clients out there who are not going to go see a lawyer no matter what, right? They're just not going to hire a lawyer. That's fine. You're not required to force somebody against their will. But the agency law has given us a standard for compliance. The agency law, RCW 1886, says that you are required to advise your client to seek the advice of an expert in areas that exceed the scope of your expertise. When the court said in 1985, you are required to persuade your client to seek legal counsel, and then 15 years later, the legislature comes along and says, if there's an issue that exceeds the scope of your authority, you are required to advise your client to seek legal counsel or to seek an expert advice. We put those two provisions together to understand what the law is with respect to this issue. To persuade somebody to seek legal advice under the 1985 decision means that, consistent with your agency law duty, you are going to provably communicate to them your advice that they seek legal counsel. This means that you're going to tell them orally and then you're going to follow it up in writing. I cannot draft that easement agreement for you. I cannot draft a joint maintenance agreement for you. I cannot draft that holdback provision for you. And then you know what, brokers? You're not going to do it. You're not going to say I can't and then do it anyway. You're going to say I can't, it's not simple, and then you're not going to do it. And you are provably going to advise your client to seek legal counsel for assistance in drafting that agreement. It might be a really long closing date. It might be the seller doing a whole bunch of really unique work for the buyer before closing. Whatever the issue is, you've got to recognize it is not simple and advise your client to seek legal counsel. If you have questions on this topic or any other, please visit warealtor.org and ask the question. Thank you for being a Washington Realtors member.